Okay, we're going live on YouTube for motion for summary judgment. Mr. Rowland, why don't you announce the case name and the cause number?
Yes, Your Honor. The case name is Wildwood Natural Corporation and Chansho Park versus GB Na, also known as Kipi Na, and the Sahana Corporation, doing business as Shinshan Oriental Market, cause number DC 1916287.
All right, let's go ahead and proceed on the summary judgment.
Before we begin, Your Honor, I believe, and I don't want to speak for Mr. Chaudhary, but we need to have a quick discussion concerning his motion for leave. They filed some late responses and some late affidavits. And then I think last night, they filed some more late responses as well. And so I think Mr. Chaudhary probably wishes to talk about that first so that we make a ruling.
Okay.
All right. Thank you, Your Honor. We have filed a motion for leave to file a late supplemental response. Let me explain. Our response was due 1 week ago. That was the first day after the holidays. We were unable to, our client, Mr. Park, he was unable to prepare and execute an affidavit by that time due to the holidays. The soonest we were able to get it was on Wednesday, and we immediately turned that over along with a supplemental response to defendant's counsel. Furthermore, last night we did file an amended supplemental response, but the only thing that added to the supplemental response that was filed on Wednesday was to make it very abundantly clear for the record the specific evidentiary citations on the no evidence motions for summary judgment. We believe our response had all of the citations, but I don't think it may be interpreted as not being clear enough. So we added that last night, and we are asking the court to grant us leave on the supplemental response and the amended supplemental response. We understand that it is up to the court's discretion here, but we want to point out that the court has given leniency and discretion to the defendants and a number of occasions in this litigation, including the defendant's expert report, which was due per an agreed scheduling order on August 24th and was filed 39 days late. And also in the Tufta case, there were discovery responses that were not served on time. We just want to make sure that this case and also the record on appeal is decided on the facts and the law and not any sort of procedural gotchas. And with that, I'll turn that over to the other side.
All right, Your Honor. We object to all this evidence, and we oppose the motion for several reasons. I think two reasons. One is just as a matter of law, they have not followed the legal standard for a motion for leave to file a late response. There's two issues.
It's hard for me to know that because it's not even up on the system, whatever. I don't think. Oh, well, maybe. I don't know. Yeah, it doesn't look like it's up on the system.
Well, I can inform the judge right now that, as the court knows, motions for leave follow the Carpenter standard, the Supreme Court's case, Carpenter. And that says what is the legal standard for motions for leave to file a late response. And it says it's good cause. And there's two parts of good cause. One has to be accident or mistake, and the other is due process. And they're explicitly clear that this is a fact determination. And as part of a fact determination, they state that you have to have evidence, such as an affidavit or a sworn anything. And in Carpenter, the Texas Supreme Court case, they applied their own legal standard to a situation just like this, in which the person did not have any affidavit and there was no sworn evidence regarding good cause. And so as a matter of law, the other side doesn't have a shred of evidence about any good cause because they don't have any evidence forward. And so just flat out under Carpenter standard, they fail. And this isn't some sort of new law. I saw this when doing O'Connor's research. It's in the legal standard of the Texas Supreme Court law. And also in our motion for leave, I'm going to read a case that's in there. It's Duchene versus Hernandez. It's talking about, this is Carpenter. This is just referencing the Supreme Court's decision. In upholding the trial court's decision to deny the motion, the Supreme Court found it significant that the plaintiff's attorney had failed to provide any supporting affidavits or other evidence in support of the motion to file a late response, and instead only presented unsworn arguments. Here later, in the present case, this plaintiff argues that they established good cause to file late. However, Duchene provided no affidavits or other evidence to support his counsel's statements that any of such mistakes occurred. Therefore, the trial court was entitled to overlook these unsworn statements. And even if they did have evidence, what their statements are is just insufficient to establish good cause because, Your Honor, as they admit, we filed our motion for summary judgment in October 13th. They've had over 90 days to respond. For some reason, they did not respond on time or get this affidavit in all of October, in all of November, and 3/4 of December, and instead just said the holidays. And I have a case also that we have in our motion in which the other people said, hey, we had the holidays, the exact same thing. They said, hey, we were gone for this last part of December. And what the Texas Court of Appeals said was, hey, you should have filed a motion for continuance beforehand because the holidays come every year. That's not accident or mistake. And plus, they had more than the amount of time. So even if they did have evidence, they fail every single aspect of good cause because they have not explained why they didn't respond in October. They have not explained why they didn't respond in November. They did not respond why they didn't do it in 3/4 of December. All of a sudden, they waited to the last second after sitting on their hands and started filing late evidence and late responses and claimed the holidays. In a lot of these cases, they were like, hey, these people had 7 days more. As they were saying, they received 8 days more than the required notice. Here's a Jackson versus Motel 6 Dallas Court of Appeals case that we cite. And they said, oh, we couldn't do it because we had to take expert depositions. And the Supreme Court said, hey, you received more than the notice. You received 7 days more. In this case, they received 90 days. And they just didn't do anything.
So first off, let me ask, because I can't see that I don't think it's been accepted yet, or at least haven't seen it. Did you file any affidavits with the motion for leave?
Oh, the affidavit of Mr. Park. If you're talking about an affidavit regarding our own issues, no. But I'm giving those statements now.
So just to interject, they filed.
Well, hey, let him finish. Let him finish.
I'm sorry, Your Honor. I'm sorry.
No, and I just want to remind the court that the court has ultimate discretion here, regardless of whatever case law that the opposing counsel has cited. The trial court has discretion to allow these late responses, and we're just trying to.
Yeah, I think it's a good cause standard. I don't think I have absolute discretion, correct?
Right, but the good cause is that Mr. Park, he was unavailable, and we got it as soon as we were available, and we turned it over immediately to opposing counsel. They had it prior to filing their response, Your Honor.
All right, I'm going to deny the motion for leave. What did we have another motion?
No, Your Honor. I think other than that, it's just people objecting to each other's evidence, but there's no other motions.
Okay. All right, let's go ahead and proceed.
All right, thank you, Your Honor. As you can see from our motion for summary judgment, the defendants are partial motion. We're asserting 3 different things, and we're really only going to focus on 2. We're asserting 1, that Mr. Na is not, as a matter of law, as a matter of Texas law, not responsible for these notes. And we want the court to focus on that because that's a question of law, not a question of fact. And therefore, the jury has no say in that determination because that's just a contract determination. It's just straight from the contract to who's responsible. It's a legal effect. Second, we're going to focus on how we have conclusive evidence that we've paid back in forms of these checks. And then lastly, I'm going to focus a little bit on the forgery. But right off the bat, I want to just say how they have not responded to their no evidence portion. We did a no evidence and a traditional, and we don't think they've effectively responded to the no evidence. So I'm going to really address that. And I'm going to address the law on why Mr. Na is not responsible. And that's what we're going to focus on. Because I understand the court's probably not going to want to make a determination on forgery as a matter of law on anything of that type of nonsense. So I'm going to avoid that. Now, right off the bat, I would like to talk about how the plaintiffs, the other side, in their motion, they say and they concede the Texas law on this standard. I'm just going to quote the plaintiff's response. If a note contains the name of an organization, followed by the name of an authorized individual in his corporate office, that is prima facie showing that the individual signed in a representative capacity and is not personally liable on the note. And in our motion, we actually bring up this great case that has the exact same pattern. Dallas Court of Appeals, it's in our thing, Shaken versus Boyd here, in which I couldn't believe the fact pattern was so similar. It's handwritten notes with just 3 lines on it, in which the company has the name there and the individual signed above the company's name. And when they said this Shaken case, it says, you know, he signed, the Court of Appeals said as a matter of law, he signed in a representative capacity. That's just the way it is. I mean, it's the exact same fact pattern as here. And so just as a matter of contract interpretation, he signed in individual capacity. And if the court wants to look at the contract,
Signed in a representative or individual?
Representative capacity.
Okay.
He signed on behalf of the Sonic Corporation doing business as Shinshan Market. And if you'd like to look at the notes, Your Honor, both sides have attached them. They're on page 101 in the PDF of our motion. If you'd like to look at those notes where it says Shinshan Market and we signed above it. In case the contract wasn't clear as a matter of law, and that's how this case had to be determined, even outside, there's all the evidence points to representative capacity. The checks that they sent us, evidencing the loan, are sent on their corporate checks, Wildwood, to Shinshan Market. That's what they're sent to. Our checks paying them back, where we're evidencing payback, are from the Sihana Corporation.
So let me make sure, wait. So let me make sure I understand kind of what you're arguing here. You're arguing that the individual should not be responsible for the breach of contract because they signed in the representative capacity.
This is just notes between 2 corporations, Your Honor, and all the evidence says that, but more importantly, the contract, which is determined as a question of law, says that. And
for the breach of contract claim.
For the breach of contract, you're asked. And
okay, all right. So let me hear a response.
Can I have one last point, Your Honor? I'm sorry, but I just want to bring up their testimony in which they admit that Mr. Na signed in a representative capacity on behalf of Sihana Corporation. They both say that.
Response?
Yes, Your Honor. First of all, to open my argument, I want to remind the court that the plaintiffs are the non-movements here. Any doubts and inferences must be construed in the favor.
I know the summary judgment standard.
Understood. There is no dispute that every single promissory note in this case is signed Shinshan Market and then Kipi Na. But the notes do not say Sihana Corporation. That is undisputed. They say Shinshan Market and then Kipi Na. Now, Shinshan Market, they claim, is a DBA of Sihana Corporation. May I share screen?
Yes.
All right. This is the Kahn v. Imperial Import case, 308 Southwest 3rd 432, Dallas Court of Appeals, 2010. And in it, it says, one second. An individual cannot sign for and bind a DBA entity. The DBA is no more than an assumed or trade name, and it is well settled that a trade name has no legal existence. Thus, to the extent Kahn purported to sign the lease on behalf of Condom Sense as a DBA, he only bound himself. Now here, to the extent Kipi Na purported—
Is this a situation where an individual is a DBA? Is this a sole proprietorship DBA case or is this a corporate DBA case?
I would like to—
Can I continue my argument, Your Honor?
Well, I just answer my question.
It is a corporate DBA case.
In the Condom Sense case?
In the Condom Sense case, yes.
Okay.
May I continue? Okay, thank you. To the extent that Kipi Na purported to sign promissory notes on behalf of Shinshan Market as a DBA, he only bound himself. But even if you could bind a DBA, it's not even Sihana Corporation's actual DBA that was listed on the promissory notes. The DBA was actually Shinshan Oriental Market, not Shinshan Market. What I have up here is one of the pieces of evidence that's attached to our response, which is the assumed name registration Shinshan Oriental Market. It's undisputed that each of the promissory notes only make reference to Shinshan Market.
Can you share screen the exact way these are signed? An example of that?
Yes, I can. Give me one.
And Your Honor, I'd like to address this case because we think it stands for an entirely different legal proposition. They've overlooked the main reason that the court held this way. In this case with Condom Sense, the reason that they held this is because the individual signing these things had never created the corporation. It says here, you can't enter a lease on behalf of an entity be formed after everything is resolved. You can't bind an entity that doesn't exist. In this problem, the individual said he had a DBA, but he had never set up the underlying corporation. If there's no corporation, there can't be a DBA. I would like the court to just look at this case they are trying to say, because what he says was he didn't set up the corporation before he signs the lease. That's what they're saying. You can't bind an entity that doesn't exist. That's all that Con is saying right here. And also, this thing that they're showing, they drafted this. They admit to drafting this. They admit it's their writing. So that has to be if they're trying to argue anything, this has to be held as a matter of law to be held against the drafter. But also, this case that they're trying to cite for this proposition just stands for the fact that you can't actually bind an entity that does not exist. And they say if he had created the underlying corporate structure, then the DBA signature would have been fine. Here, they sued Shinshan Market. I mean, let's not get this anything. They sued Shinshan Market to start this. That's who they were suing. They drafted these lines that said, these contracts that said Shinshan Market. They can't turn around and say, sorry, that's just a DBA.
So
And
wait. Let me ask a question. What you're showing me on the screen is this. This isn't the contract.
No, this is a sort of this is a translation. It's in Korean. Do you want to see the contracts themselves?
Yeah, let me see the contract themselves.
Okay, I believe I've got that here. These are examples of the contracts. This is.
So it says on one side Wildwood Natural Co., but then it's the other side is, I guess, Korean, and then beneath that is the
signature. That's correct.
Signatures, okay.
Right, and it's undisputed that it says Shinshan Market.
Right, which is who they sued as a corporation.
May I continue my argument, Your Honor?
You may.
All right. Not only did it say Shinshan Oriental Market in their assumed name registration, but that assumed name registration expired in 2008, and it was never renewed. So Shinshan Market, Shinshan Oriental Market, that wasn't even a DBA of Sehana Corporation at the time the loans were made. But even if somehow, some way you argued that Mr. Na was signing on behalf of Sehana Corporation, he's still personally liable on the notes because he failed to disclose Sehana Corporation as his principal. Here, this is the Latch v. Grady case, 107 Southwest 3rd 543, Supreme Court of Texas. This says an agent who signs a contract on behalf of an undisclosed principal is liable on the contract.
Wait. Who is the undisclosed principal here?
Sehana Corporation.
Okay, so your argument is that when he signed for Shinshan, I guess, he was actually signing for Sehana, and that's his undisclosed principal. Is that your argument?
That is my argument. Yeah, but that's my second argument after arguing that he's only signing for the DBA, and he's signing for the wrong DBA because it never said Oriental.
Okay.
Your Honor, if
whoa, Mr. Rowland, let him finish.
Sorry.
Let him finish. Stop that.
I'm sorry, Your Honor.
The next case I have is Heinrichs v. Evans Personnel Consultants, Inc. number 1, 486 Southwest 2nd 935, Supreme Court of Texas. Mary Evans, in failing to disclose the fact of her agency, subjected herself to liability as if she were dealing for herself. And Wright Group Architects Planners v. Pierce, 343 Southwest 3rd 196, Dallas Court of Appeals. That states, when an individual signs a contract without indicating he is signing in a representative capacity, he is liable on the contract. It was not Wright Group's duty to inquire or discover the principal for whom Pierce allegedly acted. It was not Mr. Park's duty to inquire or discover the principal for whom Mr. Na allegedly acted. Sehana Corporation was not used on any promissory note in this case, none. In fact, the defendants themselves say in their motion at paragraph 62, which I'm pulling up here, the record definitively establishes that the notes were between Wildwood Natural Corporation and Shinshan Market. Since Mr. Nod failed to disclose Sehana Corporation, the authority that the defendants have cited concerning their corporate defendants, they don't apply here. If the intent was truly to bind Sehana Corporation, the promissory notes needed to have clearly stated it was for Sehana. But for example, saying it was for Sehana Corporation, DBA Shincheon Oriental Market, signed by Kipi Na in his representative capacity as president of Sehana Corporation. But what the record conclusively shows is that the notes do not say this at all, let alone any reference to Sehana Corporation. And thus, Mr. Na has individual liability on those promissory notes. And then, even then, if you want to even go down further down the rabbit hole, even if somehow Mr. Na is an agent for Sehana and executed promissory notes on behalf of Sehana, he's still not entitled to corporate protections because he used Sehana for improper purposes. We've cited to the Castleberry case, 721 Southwest 2nd 270, Texas Supreme Court, 1986. An individual can abuse the corporate privilege and in doing so cause courts to disregard the corporate fiction and hold the individual personally liable. Now, in our second amended petition, we allege that Mr. Na has abused the corporate privilege through a sham to perpetuate a fraud, in that he borrowed $250,000 to invest and fund the Hebron project, which was not for Sehana's business, but instead for his own personal use and personal investments. And this had nothing to do with the Sehana retail store. Mr. Park was not loaning money to Shincheon Market or Sehana Corporation, and he never even heard of the name Sehana Corporation before this litigation. Even if it's written on checks, he doesn't read English. Mr. Na borrowed money for his personal pursuits in the name of Sehana, and he's abusing the corporate privilege. And I admit that's a fact issue. That's a fact issue, but that's a fact issue that can be decided by the jury. So ultimately our point on the individual liability is that it's clear under Kahn that by signing on behalf of a DBA, the individual only binds himself. Even if somehow signing for the DBA would normally bind Sehana, here the DBA that Sehana does not use was written on.
I get it. I get it. Response.
All right, Your Honor. I'm going to start with what the plaintiffs were talking at the very end about this disregarding the corporate form that they're asking.
I'm not concerned about that part. I want to hear your argument on the. It is pretty. If the corporation is Sehana and he signed on behalf of Shincheon and they're not an actual DBA, if that's correct, I think there's at least a fact issue on whether or not they should be personally liable. So was that a actual DBA of Sehana at the time the contracts were signed?
Yes, Your Honor, that is a DBA. It's known for that. It can tell just by their petition on how the case is styled.
No. It is legally were they a DBA? Was it or had that lapsed?
No, they were legally a DBA, Your Honor. But also,
what evidence is there of that?
I don't have any evidence, but we can look at the checks, Your Honor, in which we were sending them. They say they didn't know, and yet every single check that we gave them says the Sehana Corporation, DBA, Shincheon Oriental Market. And then the style of the case you can look at is Wildwood Natural Corp against DB doing business as Shincheon Oriental Market. They drafted this as Shincheon Market. It's not like we didn't draft this. They said Shincheon Market and we signed below it. They're the ones who wrote Shincheon Market. It's in this DBA argument, and I'm going to go to the Kahn case, and this is their case. It says, one cannot sign for and bind a legal entity that does not yet exist. This case, they had a DBA, but they had not set up the actual corporation yet. Sehana, on the other hand, has existed since the 90s. Sehana Corporation still exists. As a matter of law, they knew they put this as, and he signed in his representative capacity. They concede the Texas law says he signed in his representative capacity. They're trying to get around Texas law by stating that because we put down Shincheon, because they put down Shincheon Market when they drafted this, and we signed underneath that somehow the DBA that they wrote down doesn't allow it to be in a representative form somehow. They're trying to get a law around contract law and corporate law by their own inaccurate drafting of a DBA. And they sued Shinshan Market, Your Honor. This isn't like they didn't know. They sued Shinshan Market as a corporation. They sued Shinshan Market and they sued Kipi Na. They knew Shinshan Market was a corporation. We had to tell them, hey, the actual real name of this is Siana, but they entirely knew the entire time. And it's not like they didn't testify that Mr. Na signed in a representative capacity. Both the president of Wildwood Natural Corporation, Jin-Suk Park, and Mr. Park both stated in their deposition testimony that Mr. Na signed on behalf of Shinshan Market. They also state that all the checks state they're from one corporation to the other corporation, and they state Sihana Corporation, DBA, Shinshan Oriental Market. This is just very disingenuous, particularly because they are the drafters and they concede that Texas law, as a matter of law, states that this is a representative capacity.
Your Honor, our client refers, he admits repeatedly in his deposition testimony, he refers to Mr. Na as Shinshan Market's Nakibong. It's not that he's referring to him in his representative capacity. It's how he distinguishes one Kipi Na versus another Kipi Na. He understood that he was making a loan with Mr. Na. And yes, he drafted it, Shinshan Market, but if Mr. Na shouldn't have signed it then.
Your Honor, to respond to that,
they denied the summary judgment. Anything else, guys?
Well, you're going to deny that part, Your Honor?
I'll deny that, yes.
All right, then we're going to at least like to go forward. So Mr. Park claimed that two people saw Mr. Na witness signing these notes, his wife and a man named Moy Hong Lee. We went out and talked to Jin-Suk Park and Moy Hong Lee, and he said, these are the two people who witnessed it. Moy Hong Lee says, I've never seen any transaction between these two men. So we know Mr. Park. It was perjuring himself. We then asked his wife, were you there? And his wife said, no, I've never seen anybody draft this. Instead, we just got in a big fight and he ran out and got the signatures. That's what she says in the MSJ. So Mr. Park, we know, is perjuring himself regarding this. And like I said, unless all the disinterested parties are lying. So on this note, we're also saying that Mr. Park also says that he was never paid back a cent. That's what he says. We weren't paid back. So we would like the court to look at, on the plaintiff's motion for summary judgment, we would like them to look at Exhibit H, which is page 101 in the PDF. Excuse me, I'm sorry. I'm sorry, Your Honor. Page 79 and 80, Exhibit F. And the plaintiff's defendant's motion for partial motion for summary judgment.
Can you share screen that?
Sure, I can. All right. Sorry, I was not prepared to share this. I was looking for the other part of our earlier argument, but I can have it up in a very quick amount of time. All right, so page 79 here.
Looks like there's only 34 pages.
I opened the wrong one, Your Honor. I'm sorry. It's MSJ exhibits here. Sorry, Your Honor. So we have checks in which we paid back them, and this is how they add up. This isn't the checks themselves right here. And this is the repayment. And you can see the checks here. And first of all, I'd like to say Sihana Corporation, DBA, Shinshan Oriental Market. I know we've already decided that, but all these checks add up to $100,000. Okay. They said that they paid us $100,000 worth of checks. We have $100,000 worth of checks that we're giving back to them. Now, we're a little, what? Now, what we're saying here, Your Honor, is in their no evidence, they don't have any evidence that they've pointed to that these aren't repayment checks. There's no evidence in their response. Their motion, their response, tries to claim without citing evidence that the reason these aren't repayment is because they could be for anything. They say it could be for anything. They said it doesn't say loan repayment, and then it could, since therefore it could be for anything. But that's just argument because they have no evidence of that. It doesn't say that anywhere. They don't have any evidence on file or on the record that these checks aren't for repayment of the loan. And yet it perfectly matches the amount. They paid us $100,000 in checks. We paid them back $100,000 in checks. And it wasn't over one period of time. This is just one check, Your Honor, that I'm showing you. This was for $5,000. If you add all the checks that we paid them back, it's exactly $100,000. And all they say is, oh, it could be for something else. But they say that in a motion. They have no evidence on this fact whatsoever. And so that's our main issue, is that all their testimony is directly contradicted interested witness testimony. When they say somebody signed something and witnessed it, it turns out everybody they say saw it, didn't see it, didn't see anything. Mr. Park even said that his wife gave Mr. Na $50,000. She says no. He says they didn't pay us back a dime. We have $100,000 worth of checks saying the opposite. And they have no evidence to the contrary.
May I respond to that, Your Honor?
Sure.
Can I share screen, please?
You may.
I need Mr. Rowland to take his screen off.
Okay, go ahead.
Thank you. All right. First of all, in terms of the opposing counsel, they talk about contradictory witness statements. All that means is we have a fact issue. When you have one witness who says one thing and another witness who says another thing, that's a fact issue. But these loans were not paid back in full. They were not paid back at all. There is actually no actual evidence that Na remitted to Park $250,000 in the promissory notes, $155,639.77 on the AR promissory notes, or any amounts of the ARs from 2015 to the present. None. Now, I understand that there's these checks that they're alleging they used, but they have the burden to prove that these checks were used for loans. But I'm going to go through every single one of these. And one of the things is that many of them have notes in Korean, and they did not bother to get a translation of some of those notes. Now, for some of them, we obtained a translation for our motion for summary judgment that we filed back in May.
Let me just ask a very simple question.
Yes.
They are claiming that that there was $100,000 in payments made on behalf, I guess on it wasn't 100% clear, but on this loan, and they're saying that you didn't provide any evidence to say that it wasn't on this loan. There was no sworn testimony. Was there sworn testimony to contest this?
Well, our client has deposition testimony saying I have not received these payments. But more importantly,
was that submitted in response to the summary judgment?
Yes, it was. That was
Where, Your Honor?
The original response. But can I finish on these checks, because some of there are issues with these individual checks that we need to go through.
Well, we'll answer this question first. Show me where that you guys have contested that on this summary judgment.
Sure. Give me 1 second and I will pull that up. This is from Mr. Park's deposition. It was attached to the response and it was cited. And he says, here on page 14, this is volume 2 because they took 9 hours of his deposition testimony, which we did agree to. Because he didn't give me any money, I could not collect it. He didn't give me any money, I could not receive it. That's it. That was his testimony that he never received these payments.
Your Honor, we'd like to see in their
Whoa,
response.
whoa, stop doing that. Let him finish.
Sure.
I'd like to go through those checks because there are some checks that they didn't even attach to their exhibit. And I'd like to go through that, Your Honor. And I'd like to go through every single one because again, they have the burden. So just give me 1 second to pull up those checks again. Here we go. So the first one is 8452. That is one of the ones that we had our certified translator translate the comment there. That comment says Pulmo 1, says nothing about repayment of a loan. The next check is above that, 8519. The comment is translated as Pulmo 1. It says nothing about repayment of a loan. The next one is well, they said it's 8569, but there is no 8569 in their Exhibit F. I assume they mean 8659, and we can't even read what the memo is. There's no proof that it was used to repay a loan. 8709 is right here in the center. This is a check actually.
Wait. So, Mr. Rowland, do you have affidavit testimony that asserts or that testifies that these were used to repay the loan? These checks were used to repay the loan?
Yes, Your Honor, and it's in our partial motion for summary judgment. It's in the affidavit of Key P. Na.
And let me just make sure I'm asking a very specific question, which is, does the affidavit of Key P. Na testify that these particular checks were used to repay the loan?
Mr. Na states that they repaid them in checks.
These particular checks.
He did not specify in his affidavit in terms of check numbers, this check number, this check number, this check number.
Can I see can you share screen his affidavit?
Yes, yeah. Your Honor. And also, Your Honor.
No. Just answer my question.
Yeah, I'm gonna try to get there. We can get to his affidavit right now. His affidavit. It says, Shinshan Oriental Market paid back Wildwood Natural Corporation the full $100,000 using company checks. And then the company checks we attached as the ones.
Okay.
So those company checks that add up, that's what we have, Your Honor.
Okay. All right. That's Mr. Chaudhry. How does your client contest that statement?
Right. Well, may I share my screen back again?
You may.
I need Mr. Rowland to, I think I do. Oh, hold on. Well, that's what I was trying to continue here. My argument, for example, this is a check 8709, which is
that's not what I'm asking.
Right, I understand, but it's to Mr. Na. It says it's to Key P. Na. It's not even a how can that be a repayment back? There's even 3 checks there there's even 3 checks on their list that are not even in their Exhibit F. 9540, 9661, and 9663.
Okay, Mr. Chaudhry, I'm asking a very simple question. How does your client contest the statement made that the $100,000 in checks, or the $100,000 was repaid?
He says he did not receive them. He said
and that's the deposition you showed me. There's no affidavit or anything like that.
Well, that's his deposition saying I didn't receive payments. He's not, because the checks that are actually written to him, he's not disputing receiving the checks. What he's saying is that those checks were not used for repayment of the loan. It's their burden to prove that they were used for
there's nothing in your summary judgment response that indicates that says these checks were not used to repay the loan. There's nothing in the summary judgment response that says that. At least that you showed me.
No, but I mean, as part of our response, we did include we cited to using all pleadings and records on the.
All right, I'm going to go ahead and grant the summary judgment on that point about the $100,000 payment.
Okay. And I just want to point out that 100,000 is not the entire amount of it's not the entire amount in dispute.
I understand that. Okay. What else do we have?
We also have.
I have a. Well, can I continue? I have a point not on these checks, but on a separate related point about being paid back and not paying back.
I've already asked you the specific question, which is, did you provide any evidence?
It's a different issue.
Okay.
Very quickly, Your Honor. Let me just scroll to this next issue. Mr. Na submitted an affidavit in response to our motion for summary judgment in May and June of 2020, which we attached to our response, in which he stated in paragraph 15, Shinshan Oriental Market has paid back each of Wildwood Natural Corporation's loans in full, and Shinshan Oriental Market's balance with Wildwood for merchandise totals $49,558.27. And that is the end of his affidavit that he submitted in the summer of 2020. So he's admitting that the defendants owe $49,558.27. The amount's not in dispute, and this is a sworn affidavit. So we're entitled, we should already have a judgment for $49,558.27 plus attorney's fees, plus costs, plus pre and post judgment interest.
Okay. I don't know that that's, it's their summary judgment. I'm not going to give you judgment based on their summary judgment. So if you want to move for summary judgment on that issue, you can. I'm not sure it's quite as clear as you say, but this is their summary judgment. So you need to, I'm going to rule on what's before me. So, all right. Anything else, Mr. Rowland?
Yeah, I mean, it seems like we only got to hit on that traditional part of the motion summary judgment, but we did file no evidence. And just like we did with the last one, they have to go through and cite to their evidence, and they haven't done so. I'm going to bring up a no evidence on their fraud claim, if you don't mind, Your Honor.
Okay.
They state, and this is, we did a no evidence on their fraud. We said that they had no evidence of a misrepresentation. They had no evidence that we knew it was false when they made a representation. And I would just like to show that on their response, they do not cite to a single misrepresentation that we made. What they do in their response, and so they have no evidence of this. What they do is they try to say and so that they just have no evidence whatsoever of a false misrepresentation or that we knew it was false when we made it.
Response?
Yes, Your Honor. I mean, it is difficult to prove that point on
just point in the summary judgment record where you've raised a fact issue as to fraud.
I'll share screen. This is what we have raised. We have pointed to the deposition testimony of Mr. Chancho Park. This is one example here where he talks about, this is him talking about the entering into the notes.
Your Honor, when we were bringing up the response, doesn't say it. We just wanted to say that.
Well, Mr. Rowland, let him finish.
Right. This is the section where he talks about entering into the promissory notes. Actually, hold on a second.
Let him finish.
I paused. I knew I was being wrong, Your Honor. I'm sorry.
I just need to find it. If you just give me 1 second.
Oh, wait, Your Honor. I'm sorry.
Where? I'm just asking. Where does it say that that Mr. Rowland's client committed fraud?
It doesn't say that, Your Honor.
All right. Summary judgment on the issue of fraud is granted. What else do we have?
And we're just going to have to keep on going. No evidence. We don't think that there's any evidence they have that. For also the quantum merit claim. They think that they have no evidence. We went through in our no evidence summary judgment saying that there was no evidence that we received anything, particularly Mr. Na. They're suing him that he's received all these things. We're saying they have no evidence of that.
Response?
Your Honor, first of all, they admit that there were services and materials that were furnished. He admits the AR balance 49,558.27. That's an admission that he received things, but I will also put up testimony, if you'll just give me 1 second, regarding that.
Okay. Did you specifically respond to the quantum Merowith argument within your briefing?
Yes,
Your Honor, that's one of the things that I just like to clarify is we can't just show deposition testimony. We'd like to see in their response where they actually cite to these things that.
Right. No, I agree with you, Mr. Rowland. Where do you cite in your response to the deposition testimony?
You want me to point to the response?
Well,
because what we've done is we cited in our response to the statements and all of the statements and invoices that come from that Wildwood Natural Corporation issued.
Within your response, do you respond to the quantum Merowith claim?
Yes. You want me to pull that up, Your Honor?
Yeah, pull that up.
Sure.
Are you pulling it up?
Yes, I'm pulling it up, Your Honor. Just give me 1 more second.
Okay. Okay, that's your response?
That is correct, Your Honor. We did have more in a supplemental response with more, because I just didn't want to repeat all of the string sites, but I understand that the motion for leave was denied.
All right, I'm going to go ahead and grant summary judgment on the issue of quantum Merowith. What else do we have?
Your Honor, and this is just continuing our no evidence, and I'll keep it brief. The exact same thing is they have no evidence that Mr. Na represented anything that he'd be personally liable. They say this is a part of the breach of contract that Mr. Na, they say they signed a contract. They say Exhibit E, and then they do a bunch of citations, and then they say there is evidence defendant Na represented a plaintiff that defendant Na would be personally liable on the AR promissory note C-ID. On all those string of citations, we don't think there's any.
I've already ruled on this issue, haven't I?
Yeah.
Yeah, but we thought that was on the traditional side, Honor.
No, I'm still denying that one. What else do we have?
Okay, I think that, is there anything else that they said that the breach of contract case, we don't think that they have evidence concerning that Sihan is liable. Because if they're saying that Mr. Na is liable, that they don't have any evidence that Sihana Corporation is liable.
I don't understand that, Your Honor.
I don't either.
Your Honor, what we're saying is you can't have a contract with both Mr. Na and with Sihana Corporation if they're trying to say that these notes that they have evidence that these notes were contracted with Mr. Na. They do not have evidence that they were contracted with Sihana Corporation. They have to have evidence that there was a party to the contract on one or the other.
We're not arguing that Sihana Corporation is bound on these notes. We're arguing that Mr. Na is bound on these notes, and summary judgment has been denied on that, and also no evidence.
Summary judgment's denied on this point.
All right, then the last no evidence would be regarding promissory.
I apologize. I need to take a quick. Sorry about that. Go ahead. Do we have anything
Yeah.
else?
It's just the no evidence on the promissory estoppel claim, Your Honor.
Okay.
It says plaintiffs have provided evidence these amounts were not repaid at all. We've actually said that they have been. We don't think they have any evidence to support their promissory estoppel claim. We went through in our no evidence, and we don't think they responded to it.
And you'll see here, we cite in our response to every single portion here in Mr. Park's deposition that specifically relates to the promise that
All right. The promissory estoppel is denied.
Thank
Or
you, Your
the
Honor.
summary judgment has to it. Anything else, guys?
No, Your Honor.
Okay.
Well, there's one issue that's not related to summary judgment that I wanted to bring up.
Okay, what's up?
Last week we had talked with the court about continuance on the trial date. Our position is we think that it doesn't make sense for everyone to get ready for trial and then come up to February 16th and have it pushed out. 1 week ago, we did ask the defendants if they would agree to a continuance to September 21st of this year, and we have not received a response, but I thought we might as well bring it up now because if it can save us some sort of motion practice, it's probably better to do that.
Mr. Rowland?
We haven't been able to talk about to our clients. We didn't actually object. I told Mr. Chaudhary that a lot of that seemed very reasonable. We just had to get authorization from our clients regarding that. And as soon as we were going to be able to do so, we were going to respond to that and have some sort of agreed motion or agreed order about that. We're certainly open to it. I just couldn't give it the go ahead until we've spoken with our clients.
So you do have the go ahead now?
Well, Your Honor, I don't know that we were ready to talk about this with Mr. Chowdhury. This is Talem Song. I'm happy to talk
if you're
to
not
Mr.
ready
Chowdhury.
yet, it's totally up to y'all. I don't think we'll be able to do a jury trial that week, but if you want to talk to your clients and get back to us, I'm okay with that. I'm not trying to put you on the spot.
Thank you, Your Honor. And thank you for all your hard work, Your Honor.
Okay, anything else, guys? And I need an order on this. And I took notes on it, but if you guys, Mr. Rowland, if you can prepare an order about the granting and denying of each of the different claims and run it by Mr. Chaudhary and try to get that to me as soon as you can.
All right. Thank you, Your Honor.
All right. Thank you. You guys have a good day.
You as well.
Okay. I think we have one more hearing. Are both sides here for the hearing? Mr. Reniker?
Yes. I'm Evelio Zapata.
Uh-huh.
Excuse me, I was muted, Judge. I'm here. Plaintiff is ready.
Both sides are here. Okay. Let me just give me 1 second to pull this up and we'll get started. This is on Balloon City, correct?
That's correct.
Okay. Do y'all want a record on this?
I don't think we need one, Judge.
Okay.
This is a pretty simple motion to compel the responses to post-judgment interrogatories. According to the motion, those were served on October the 6th. I still haven't had a response. In November, around November the 25th, I believe, I filed a motion to compel, asking him to file a written response and to produce the documents that I've requested. I'm also asking the court to award attorney's fees for having to present this motion.
Response? Mr. Zapata?
Yes, sir. I apologize for my dog. He's locked up. Sorry, I'm trying to write these notes down. So I was unaware of this, of what was going on. I have since then changed addresses, and my lawyer has since then retired and moved to Corpus. I found out about this through a text that was sent to me a few days ago. Thankfully, Mr. Reniker sent me that text, and I got a hold of your office, and now we're here today, thankfully. So my response would be if I could have like another 30 days or so I can go ahead and reach out to an attorney and hire an attorney so this attorney can send over Mr. Reniker everything that he's needing, and we can go ahead and get everything settled out and payment continuing. Unfortunately, because of COVID, I did fall behind. There was a lot going on through COVID that I don't want to keep everybody in the midst of, but there was just a lot that was not good for me, which is why I fell behind on my payments. But I'm ready now to like continue payments and get everything that Mr. Reniker needs over to him, just so that we can move on with the process of continuing this.
30 days, okay with you, Mr. Reniker?
That's fine, Judge. He just said he changed addresses. I mailed everything I mailed to him. I send to 2 addresses. I get green cards back from at least one of them. I'd like to know what his current address is that's good, where I can get it to him, and perhaps a good email address that he would respond to rather than text messages.
Mr. Zapata, can you go ahead and give him and Rhonda, if you could take this down as well so we can have it in our system. What is the best address?
The best address is going to be 1919 South Ackard, AKARD Street, Dallas, Texas, 75215, apartment 131. And the best email is going to be info, INFO.
I think he's frozen. Info.
I bet he's going to say info at easy party time.
You cut out there. You said info at what?
Info at easypartytime.shop. SHOP.
.shop or .com?
Shop. SHOP.
I've never heard of that. Okay. Sounds good. Mr. Reniker, what I usually do in this situation is, and Mr. Zapata, is I'm going to give you 30 days. If this is kind of your last shot, we're going to take you at your word that this was just an honest mistake. But if you don't do this, what were you going to request in attorney's fees, Mr. Reniker?
$500, Your Honor.
Okay. So if you don't answer these within these requests within 30 days, then you'll be responsible for paying $500 in sanctions.
Yes, sir. Yes, Your Honor.
Okay.
And
Anything
Your Honor,
else, guys?
I uploaded an order through the e-filing system, so there's a proposed order there. You may have to interlineate for your.
I will. I already got it and I printed it out and I'll interlineate it. Okay. Anything else, guys?
That's it.
All right. Thank you, Mr. Reniker. Thank you, Mr. Zapata. You guys have a good day. Okay.
Thank you.
Good. Thank you, Judge.
Okay. Why don't we chat real quick?